issues are too gripping.
Rise if able.
My Lord, before moving on to the legislative history, which I'm sure we're waiting for, can I just quickly deal with one case that my learned friend mentioned yesterday, which was the Herons-Lee case, which is at tab 8 of the authorities bundle. And he relied on that for the proposition that in connection with can be construed narrowly or widely depending on the context. And the short point on this really is that there is no dispute in this case that the ordinary meaning of the words in connection with will have a wide meaning. The point that Lord Justice Hamblin, as he then was that he was looking at the statute and the other words in the statute as well, and the context of the use of the words to form his own view on what it meant there. But that doesn't derogate from my points, which are firstly that the ordinary meaning of in connection with is wide, and secondly that the context here supports the wide construction for which I'm contending. The third point is put another way: there is nothing comparable to the Heron-Lee case which would show that a narrower meaning was appropriate. And if I can just remind you of the Heron-Lee case, the issue, if your lordship wants to have a quick look at the head notes, you may remember it from my learned friend's submissions, but the issue was whether an authorised inspector, capital A, capital I, who had inspected and signed off on compliance with building regulations over a block of flats was liable for defects in the building.
Approved inspection.
Approved it, yes.
Approved inspection.
Was liable for defects in the building under the Defective Premises Act. And the relevant statutory provision is at paragraph 10 on page 167. And section 1.1 establishes liability for a person taking on work for or in connection with the provision of a dwelling. And the question was whether that covered the inspector. And the Court of Appeal held that it didn't cover the inspector, notwithstanding the submission that the words in connection with had a wide meaning. And you can see the submission that was made recorded at paragraph 36.1, and that's at page 174. And Lord Justice Hamblin, as he then was, gave his finding at paragraph 37, which is the passage relied upon by my learned friend. And obviously the learned judge accepted that sometimes that would mean the words are of the widest imports, but others times they won't. In the context of the present case, paragraph 38, and looking at the entirety of the words of the statute, the court decided that little assistance was to be gained from other cases. And obviously we're not suggesting that the words in connection with are given the same meaning as they're given in other contexts. We're simply saying it should be given the ordinary meaning based upon the Conoco case. But the second point is that the reason Lord Justice Hamblin likely derived little assistance from the ordinary meaning of the words was because the interpretation was determined by the other words in the statute, namely the words provision of a dwelling. And at paragraph 39, Lord Justice Hamlin noted that the test is whether the work is carried out in connection with the provision of a dwelling, which suggests the bringing of that dwelling into physical existence or its creation. And then at paragraph 40, His Lordship concluded that section 1.1 applies to those who positively contribute to the creation of the dwelling, but not to those performing a negative regulatory role. So the inspector was not within the scope of section 1.1 of the DPA because its work lacked a sufficient connection to the dwelling. Not because its work lacked a sufficient connection to the dwelling, I beg your pardon, but because its work was not connected to the provision, i.e. the creation of the dwelling. So
do I understand, in effect, your submission is that this was a case about the meaning of the word provision rather than the meaning of the words in connection?
yes, and certainly the totality of it, the in connection with the provision, if I can put it that way, it's not simply about the words in connection with. And in fact, the second point is that, following on from my Lord Justice Arnold's point, this case therefore is not authority for giving the words in connection with an unusual or narrow meaning. Now, no such distinctions in any event can be drawn here because there is no doubt, unlike in this case, that there is a connection between an order under section 140B affecting a mortgage, if an order is made to repay sums under a mortgage, and the mortgage itself. So that's the other point, that here you can see what the distinction was. On the facts of this case, there's no distinction to be drawn, as my learned friend would have to. May I then go to the legislative history, because my learned friend seeks to place heavy reliance on the extortionate credit bargain regime to support his interpretation of section 140A subparagraph 5. And we suggest that the reliance is misplaced for two reasons. The first is that one, in fact, gains very limited assistance, if any, as to how to interpret the unfair regulation provisions from the earlier and different regime which was repealed and which the unfair relationship provisions replaced. And the second point is that, in fact, the legislative history supports my case that the clear intention of Parliament was to exclude regulated mortgages from regulation under the CCA following the introduction of FSMA and MCOL. So, starting with the first point, I fully accept that it can sometimes be relevant in interpreting legislation to consider prior legislation, but not where Parliament's intention was to repeal the old regime and entirely replace it with a new regime. And my learned friend recognises as much in his skeleton at paragraph 42. And there, if your Lordship looks at that, it's in the core bundle, tab 14, at page 228. Subparagraph 3 correctly identifies the reasons for replacing the old extortionate credit bargain regime, which was that it was focused on the cost of credit and the bar was set too high. And then at 4, the claimant's note that
paragraph exactly?
it was 42 subparagraph 3 on page 228.
Thank you, I'm sorry. Yes.
And then the next subparagraph down, the claimant's note relying on the dicta from the Supreme Court that the unfair relationship provisions are discrete new provisions replacing the discredited extortionate credit bargain regime. So in these circumstances, the right approach must be to construe the new legislation on its own terms. And as I've already submitted, the new legislation clearly excludes regulated mortgages from the orders that can be made under section 140B. And critically, that was intentional because it reflected the fact that Parliament's intention was to leave the policing of mortgages to the new FSMA regime that was introduced, taking them out of the CCA to ensure that there is not dual regulation. And I'll show you a bit more about that because that takes me to my second point. And that is, with effect from the 31st of October 2004, entering into an administering regulated mortgage contracts became a regulated activity under the Financial Services and Markets Act 2000, which was regulated by the FSA, now the FCA, and subject to the rules and guidance in the FCA handbook, specifically the MCOB rules. And indeed, you've seen the pleading for a breach of those rules. Simultaneously, the clear legislative intention was to effectively remove regulated mortgages from the scope of the Consumer Credit Act, which is accepted by the claimants in their skeleton at paragraph 59 in the first sentence. And just to make that good, may I show you the relevant enabling legislation, which is the Financial Services and Market Act 2000 Regulated Activities Order 2001, which is the statutory instrument by which consumer mortgages became a regulated activity under FSMA. And you can see that in the authorities bundle at tab 25. So at 61 subparagraph 3A, we can see that regulated mortgages as defined becomes a specified kind of activity, 61(1), similarly administrating the activity. And the same legislation removed regulated mortgages from the CCA regime, including specifically the extortionate credit bargain regime. And may I show you the explanatory note to the order that you have in front of you, which is in the supplemental authorities bundle at tab 4. So you see part 4, which is where the highlighting is marked, makes consequential amendments to the Consumer Credit Act 1974 and subordinate legislation under that Act, so as to exclude from its scope those categories of mortgage contract which are specified under this order and will therefore be regulated under the Act, which is defined at the top as the Financial Services and Markets Act 2000. And that was then implemented in part 4 of the 2001 order. And then, my lord, if we go back to the authorities bundle that you had open at tab 26.
Sorry, I'm just understand, trying to keep up. So the explanatory note is the 2001 order.
Which was at tab 25. We had open.
and that the heading of page 363 and tab 25 is part 2.
Yeah, so that is the
I see. So
part
that's
that-
bringing in the
that's
activities.
bringing in the
Yes, I see.
activities.
Yeah.
And the explanatory
And then
note
part
makes
4
plain that
takes
part
out.
4 is taking it away.
Yes. Okay.
And then if we go over to 26, at page 368, a new section 16(6)(c) to the Consumer Credit Act. My learned friend showed you this yesterday,
Yes.
shows that the Act does not regulate a consumer credit agreement if it's secured by a land mortgage. Or little b as well, entering into that agreement as a lender is a regulated activity for purposes of FSMA. And then, my lord, if we go then please to tab 27 in the same bundle. The Consumer Credit Act expressly removes regulated mortgages from the scope of the extortionate credit bargain provisions. So I was tab 27 at 372. And then it's section 1(2)(a). And you see other than an agreement which is an exempt agreement as a result of section 16(6)(c). And then if you go over the page to 373, you see in the notes, there's a footnote 1 to that word, those words over the page that I've just shown you, words inserted by Part 4 of the Financial Services and Markets Act 2000. So that is why I was saying that legislative intent is clear. At the same time as Parliament moved consumer mortgages to be a regulated activity under FSMA, it removed them from the then existing consumer credit regime, including the precursor to the unfair relationship provisions. And just to make this absolutely clear, you can see that as well from the government consultation documents at the time. So, for example, in the supplemental authority bundle at tab 3, there is a second consultation document on the 2001 order prior to its enactment. And you see by way of summary at paragraph 5.4 on page 17 what's covered, and part 4 is the one that's making the consequential changes to the Consumer Credit Act 1974 and traditional provisions with respect to mortgage contracts. And then if we go on to page 21, you see the heading part 4, consequential and transitional provisions. It says in terms, the intention is that mortgages which are to be subject to regulation under the Act should no longer be covered by the Consumer Credit Act, CCA, to the extent that applies to mortgages. And 5.45, the effect of these provisions will not be subject to, is that a mortgage will not be subject to dual regulation under both the CCA and the Act. And if you look just above that at the bullet points, extortionate credit bargain provisions of the CCA are not to apply to mortgages regulated under the Act. And then that was then, of course, then continued to be reflected in the unfair relationship provisions introduced shortly after the 2006 Act. Now, yesterday, my learned friend showed you.
Sorry, this refers to Article 84. Do we have Article 84?
I don't think we do, my lord, but we can get a copy for you if you'd like.
You're relying upon a consultation saying the extortionate credit bargain provisions don't apply, which seems to be kind of relevant to your argument. And yet we don't have the operative provision.
Sorry, it's from an earlier version of the 2001 order, and it's the provision 84 is what becomes section 90 that we have.
Right. Okay.
But I take the point, and we can provide that just so that you can see, and I can make that good.
So remind me, where do we find Article 90 as it is now?
So we showed you, my lord, in tab 27, the footnote referring to Article 90 that introduced the words with the exempt agreement wording into the Consumer Credit Act, removing mortgages from extortionate credit bargains.
And in the same vein, presumably, note 16 at page 370.
Exactly, my lord. But I take the point, and we can certainly provide copies of the underlying articles if I don't think points are taken on this by my learned friend, but if they are, certainly I would like to see it.
I think that's really
Thank you. Now, yesterday, my learned friend went to tab 31 in that same bundle, in the authorities bundle, to show you the research paper on the Consumer Credit Bill, the draft 2006 bill, to emphasise the intention to broaden the regime to the whole credit relationship. And we don't take a point on that, but what he didn't show you is at page 562, which is the section covering unfair relationships. And in particular, at the bottom of the page, you see the types of agreement covered by this new unfair relationship test are defined by new section 140C inserted into the Act by clause 21. Basically, any regulated agreement that involves the provision of credit to an individual will be covered. And then you see right at the end, however, the unfair relationship test would not apply to consumer credit agreements secured on land that are already regulated by the FSA under FSMA 2002. And if you would just look at the footnote to that, which is at the bottom 88, and then for completeness, the same point is made in the middle of page 578 as well. And then if we go on please to tab 32, these are the explanatory notes to the 2006 Act. And if we look please at page 611 at paragraph 48, So we see that explained and implemented. So the judge below was correct to find, as he did at paragraph 206, that the intention of Parliament in enacting section 140A5 was to exclude regulated mortgage contracts from the scope of the CCA unfair relationship provisions on the basis that they're subject to their own regulatory framework. So pausing there, my lord, we say that should be the end of the matter, but my learned friend's case, which has come in, I think particularly through the addendum note, is that regulated mortgages in fact could still be subject to the old extortionate credit bargain regime after the 31st of October 2004, and as such Parliament must have intended the same, if you like, lacuna on his case to apply when the unfair relationship provisions came into force. And this is, just for your note, addressed in paragraphs 55 to 56 of their skeleton argument, and in particular paragraph 6 of the addendum note. And my lord, we say this is a bad point. The argument, such as it is, which is set out in the addendum note, can be summarised as follows. Firstly, the claimants accept that following the 2001 order, Parliament carved out regulated mortgages from the meaning of credit agreement for the purposes of the extortionate credit bargain provisions. But my learned friend says, and this is the second step, it did not exclude them from the meaning of credit bargain. And may I show you the relevant provision, which is at tab 27 of the authorities bundle. So we have 1372 little a, which we've looked at, which carves out regulated mortgages. But below that, the definition of credit bargain includes in little b2 the words other transactions, where they are taken into account in computing the charge for credit. And the extortionate credit bargain provisions allow the court to make orders in relation to such other transactions as well as the credit agreement. So my learned friend's argument is a regulated mortgage could be a other transaction, notwithstanding everything we've seen, and therefore an order could be made in relation to a regulated mortgage under the old regime, and therefore the replacement unfair relationship regime should be read as including the same power. That's quite a convoluted argument, and it does fly in the face of, first of all, the parliamentary intention, and secondly, the unfair relationship provisions. But it also, we suggest, it isn't a sensible argument on its own terms. It's unreal, we suggest, that a mortgage would in fact be taken into account in calculating the total charge for a loan. And the position is, under the extortionate credit bargain provisions, that when you see the passage you have open, little b2, and sorry, little b1 as well, you're looking at where the credit agreement plus another agreement is to be taken into account in computing the total charge for credit. And what is to be taken into account in computing the total charge for credit is determined by the Consumer Credit Total Charge for Credit Regulations 1980. And the relevant part of that instrument appears in tab 19. So section 4 covers the items to be included in total charge for credit, and little a is the obvious one, interest on the credit. But it can also include under little b other charges payable under the, quote, transaction. Now, transaction is defined in the authorities bundle at tab 18 in section 1 subsection 2, and that's page 344. And critically, it needs to be an agreement, and your lordship will look at the penultimate line, that not only fits the first 4 lines, but and which the creditor requires to be made or maintained as a condition of the making of the agreement, i.e. the credit agreement.
So sorry, those words you say govern the whole of what comes before or some part of what comes before?
The whole of it, because it's got the word and. So it means an agreement, any transaction which is a linked transaction by virtue of 19(1) of the Act, any contract for the provision of security relating to the agreement, and any other contract to which the debtor or relative of his is a party, pause, and which the creditor.
Yep.
And that is consistent with the fact that in section 19(1)(a), it expressly identifies that not any linked transaction is a transaction relevant to the charge for credit provisions, but only those linked by reason of section 19(1)(a). And you can see that from tab 15 of the authorities bundle.
I'm just going to note something briefly, which is I think that the version of section 19 that we might have in tab 15 is the current version. I'm exploring that now, because obviously when one is analysing what is referred to as a linked transaction in the total charge for credit regulations 1980, it may be that it's a very slightly different version, and I have a recollection from my work in advance of the hearing that may be the
There's
case.
been some change.
It's not, I don't think it's materially different, but we're checking the position.
Yeah.
Thank you. So what you can see from 19(1)(a) is that the transaction is linked if it's entered into in compliance with the term of the principal agreement. So that means it's a separate agreement which the credit agreement requires the debtor to enter into.
Could we go back to that definition section, which we were just looking at before Mr. Sowell?
I think it was 18, tab 18 for
Yes,
transaction.
page 344. Do I understand, I'm sorry for being a bit slow, that your contention is that the last words in that session, and which the creditor requires to be made or maintained as a condition of the making of the agreement, qualifies all the meanings under the transaction, and not just the last one that begins any other contract to which the debtor is.
It qualifies all of it, and one sees that because 19(1)(a) is entirely consistent with that reading of the definition.
Actually, otherwise, you would be left with an agreement on its own, wouldn't you?
Exactly.
Yes.
And so what's required, therefore, is you have to have the credit agreement requiring the other transaction to be entered into. And then, if that is what occurs, the published rate, typically the APR of the credit agreement, would need to reflect not only the interest charged under the credit agreement, but any charges under that separate agreement. And the consequence of that, therefore, is that for a regulated mortgage to be captured within the definition of credit bargain, first you need to have a credit agreement which obliged the customer to enter into a mortgage contract. and so a separate credit agreement and then a separate mortgage. And the APR for that credit agreement would have to take into account both the interest rate under the loan plus all the interest due under the mortgage. So it's extremely unlikely that that would occur, because it's extremely unlikely that a loan agreement would have a term which required the customer to take out typically a much larger residential mortgage. And no one, we suggest, would structure a loan in that way, because the lender would be required to show the total charge for the loan as an APR, which included not just the loan interest, but the much larger, typically, mortgage interest and charges. But critically, in any event, that was not how the together loans in this case were structured. They were not structured for the loan. The loan did not provide that the mortgage had to be entered into. So the alleged lacuna would not assist anyway. But one can see that the assertion that regulated mortgages could still be subject to an order under the extortionate credit bargain regime because of this point, it is illusory. The proposition that a mortgage contract could comprise part of another credit agreement's credit bargain does not accord with reality. But the reality is that even if I'm wrong and there was an oversight, or as we say in our skeleton at paragraph 60.2, an anomaly, that cannot be extrapolated to reflect a deliberate parliamentary intention, which is my learned friend's case. And I've shown you that the parliamentary intention was clear, the opposite, and everything I've shown you speaks with one voice about removing regulated mortgages from the CCA, including expressly from the extortionate credit bargain regime and its successor. There's not a single suggestion, other than the case my learned friend is advancing, but certainly nothing in the materials before you, that it was intended that regulated mortgages could come back into the regime by the back door. And the contrary is true. Now, the next point, the third point, my lord, is that even if there were a lacuna in the old regime, we are concerned with an entirely new set of provisions which uses a different exclusionary device. And the unfair relationship provisions do not have the concept of credit bargain, nor technicalities as to whether something is or is not relevant to the calculation of the total charge for credit. And the terms in which section 140A5 are expressed are clear. So whatever the prior position, the language used in the Act, coupled with the intention stated, is plainly designed to remove regulated mortgages from the new regime. And I mentioned the COVID-related loans earlier, but it's relevant that the same legislative technique was used subsequently to remove COVID-related loans from the scope of the CCA. So if we look back at tab 17, at 140A subsection 6, now, it would be entirely consistent with the claimant's case that it must be inferred there was a parliamentary intention to remove the COVID loans from the CCA, but only insofar as they were themselves the credit agreement, but not if they were the related agreement, and therefore they would come back in as well through the back door. So my learned friend's arguments would have consequences that go beyond just regulated mortgages, and that's not encapsulated by his arguments on the extortionate credit bargain regime.
I mean, we've got no way of knowing, have we, how often you could have that sort of situation in a COVID context.
You don't, but I'm just making the point that if that's the statutory construction, it might well apply using the same
Yes.
approach to 6, which would be consistent if that was the right interpretation. But that's no part of my learned friend's case that that's somehow the consequence of the
Yes.
extortionate credit bargain regime, because obviously this is new. And his answer to that would be, well, this is new. Well, the same is true of Section 5. So for all of those reasons, the legislative history is we would say, a red herring, because you have the provisions in front of you that should be interpreted on their own terms, and this is not a scenario in which the history helps. But in any case, the history doesn't help him, because the history shows clearly that the intention was to remove mortgages from the prior regime. So he then falls back on a case about a lacuna, which we suggest doesn't work in real terms, wouldn't apply to this case anyway, and if it really is true, would be a lacuna. So it couldn't have been intended then, and still less was it carried across now. So that's, I think, the end of his case on section 140A5. My lords, I don't know if you had any questions on that.
No, thank you very much. Thank you.
I just had two
Yes.
short points just to finish on before I sat down. The first was, with my apologies, a correction. I referred at the transcript, day 2, page 63, line 19, to the fact that various borrowers have subsequently had access to product transfers and have taken advantage of them. It is correct that they have all been offered product transfers. I said that at least half the claimants had taken them up. In fact, the position is that at least, or over half of the claimants have subsequently redeemed their mortgages, but I don't know whether that's by product transfer or remortgaging with another lender. So I just wanted to make that plain.
Yeah.
I think there's a question going behind me about, do I mean claimants or borrowers? But I mean claimants, I think. Yeah, that's what I'm being told. So I just wanted to make that correction because I put it
Yes.
in a particular way. I don't think that's actually accurate. The second point, my lord, is just briefly to come back to a question that my Lord Justice Newey asked at the transcript on day 2, page 34, line 10. I think my recollection is that Lord Justice Arnold answered the question, but I just wanted to put it on the transcript, which was that the question was whether 2 different offer letters in the terms before you on the same day could have 2 different SVRs, and therefore could TSB set different SVRs for different Whistletree borrowers. And I explained why that was not realistic in practice. And I think my Lord Justice Arnold correctly pointed out, but I'm not sure I made it plain, that it's also not possible under the contract because the standard variable rate as defined setting the offer must at all times satisfy the definition of SVR in the conditions. And there can only be one SVR at any given time that satisfies the definition because it's a numerical number. I think my learned friend agrees with that. So there can only be one SVR that applies across the portfolio. You can't salami slice the portfolio into ever smaller cohorts. So my lord, that was the contractual answer. Now I think my Lord Justice Arnold referred to that point, but I just wanted to make it plain that I
more than I was intending, but thank you for
that's I just wanted to be clear that that's my argument. I've been told that if Lord Justice Arnold didn't make that point, I should finish it. So I will just you bear with me. I don't know if you want to go back to the definition or if you're happy, my lord, with that explanation.
Well, I think it would be helpful.
So if we could go back to the supplementary bundle, please, at tab 9. And it's page 155. So the standard variable rate must be a rate that is set by the lender from time to time as the base, and the base is singular, from which to calculate defined term interest on our variable rate mortgage loans. Loans is plural. So that means in my submission there must be a single base which applies to all the loans on which interest with a capital I is charged. So a single SVR that applies for all mortgages for which the relevant lender calculates interest.
Sorry, can you
under-
just say that more slowly? There must
I'm
be
so
a
sorry.
single base which
That
applies
to
to
all of the loans on which interest with a capital I is charged, i.e. the Whistletree portfolio, to which these conditions apply. And that is a single SVR that applies for all mortgages for which the relevant lender calculates capital I interest under these general conditions. And you obviously have my separate point that a lender can have different SVRs for other portfolios of mortgages which have different terms applying to them and don't carry interest as defined under these conditions. And for example, we know that TSB has numerous portfolios to which different rates apply and they're each governed by different terms. But in answer to what I think was your question, my lord, you couldn't, under these conditions properly interpreted with the offer letter, issue on the same day a different interest rate because they're all governed by the same conditions. And my understanding is, my learned friend accepts that the SVR is a numerical rate.
I don't detect. No.
But going back to the question that I was asking, or the observation I made, however one characterises it, I don't recall. One also needs to take into account the second sentence, the current standard variable rate, and so I think that's consistent with what you just said, which applies to your loan, is set out in the offer, and that means that the borrower isn't left, as it were, looking it up.
Exactly,
So it is tied into the documentation,
exactly.
and so therefore you can always track it through from the SVR that's set out in the offer.
Exactly right.
Thank you
Thank
very
you.
much. Mrs. Hull.
Well, I will start, if I may, with issue 3, given that you just heard from my learned friend
Yes.
on that point, and then I will address issue 1 afterward. In general, my lords, I maintain the points I've made yesterday, as well as those in the skeleton and the addendum note. It was suggested that I developed some points more than others already, but that's how all submissions go. And I dare say I used up all the time I had. Issue 3, please. It is a simple point that we make. An order that bears on a mortgage as a related agreement is properly characterised under this legislation as an order made in connection with the credit agreement, just as it would be in relation to any other related agreement. Any other related agreement, the order made that concerns it is an order made in connection with the credit agreement to which it's related. That's the language of the statute. So the question here is as to the impact of 148.5. Now, we don't seek here to give any special meaning to the words in connection with. The words, in any event, we say have to be applied in their context. We do maintain what Lord Justice Hamlin was saying in the Heron's case, which you've been taken to as paragraph 37 that I rely on, is a broad application. And you have to look at the meaning of whatever the words are, you have to look at them in their context. And looking at other contexts, other facts, other legislation is unlikely to assist. And for example, in the Heron's case, my learned friend said it's really about the words in that case in connection with the provision. Here, the relevant words are in connection with the credit agreement. And the purpose of this legislation is what matters here, interpreted in its context. And so we have to ask ourselves, what does this entire phrase in section 140A5 mean? An order shall not be made in connection with a credit agreement, which is an exempt agreement. What is the intended effect of that language? And it is the same language in connection with the credit agreement that we see in 140A1 and that we see in 140B1. So it should be interpreted in a consistent way. And what this language does is it identifies the gateway. It identifies the agreement which engages the jurisdiction. It is neither narrow wording, nor is it wide wording. It is just what it is. It is not what it is not, is delineating or circumscribing the agreements which can qualify as related agreements, and in respect of which relief can be granted. Now,
The same wording is used in 140A5, isn't it? In connection with the credit agreement.
in connection, yes, it's the same wording in 140A1, 140A5, and 140B1.
And 148.5 says, shall not be made in connection with a credit agreement, which is an exempt agreement.
Absolutely. And what that is identifying is how you engage the jurisdiction. Now, just to sweep away one point, I used the word anchoring briefly yesterday. It was an attempt to use a different linguistic formulation. I would suggest respectfully that gateway or the agreement which engages the jurisdiction are better formulations. It's my fault. But there was then a debate with my learned friend about what anchoring means, which then effectively set us off on the wrong path. But I want to make clear, relative values of the two agreements, of the credit agreement and the related agreement, the nature of the rights under them, whether one relates to more money than the other, for example, are wholly irrelevant to this question. If you have a credit agreement that is not an exempt agreement, then the assessment in section 140A is available and the powers in section 140B are available.
You are retreating from the use of the word anchoring, but never mind what label one applies. What's your answer to the point that the effect of your construction is that if you start from one agreement as opposed to the other, you get the opposite result? So it all depends on which agreement you start with.
My lord, I listened to that argument. I respectfully disagree. It's analytically that I was going to come to it, but analytically that argument is completely hollow. All it says, all that argument involves, it's circular, or it's a truism. But all it says is, if you start with an exempt agreement, then you can't get in. Well, that's obvious.
What does gateway mean?
It means that you
encouraging us to ignore the anchor and to go to the gateway.
Well,
So
it
how does
means
that
that the
work?
provisions are in play. Section 140A to C are available, and including the powers in section 140B. If you have a credit agreement which is not an exempt agreement, then the unfair relationship regime is available and engaged. That is what it means. And to say, well, if you start from your exempt agreement, you can't get in, well, that's obvious with respect. It doesn't take the analysis analytically, really scratching the surface of that argument. What does it mean? It goes nowhere, my lord, with respect. I do understand why my lord wanted to raise it with me. I was thinking about it, but it's analytically completely circular. Of course, if you start with an exempt agreement, you don't go in. But what matters for the unfair relationship regime? Do you have a credit agreement that is not an exempt agreement? Yes or no? Obviously, if you start with the wrong agreement, then you get the other answer. But that's because it's exempt. It tells us nothing. And so what section 140B, sorry, section 140A5 is doing is it is prohibiting the mortgage agreement from being the gateway. It cannot be the credit agreement, as in inverted commas, for the purposes of invoking the jurisdiction. But in no way does that fetter the menu of options available to the court by way of remedy, which include remedies bearing on the related agreement. Now let me show you, my lords. If you look at how section 140A5 itself is drafted, Authorities Volume 2, tab 17. First of all, let me make another point, which I made yesterday. Apologies if it's an unhelpful repetition. The definition of related agreement in the legislation does not exclude exempt agreements. It could easily have done.
Sorry, when you say the definition, you mean
There is a definition of related agreement.
subsection 140C C4?
Yes. It does not exclude exempt agreements. It could easily have done so if the intention of Parliament was for the court to have no power. If the intention was for the court to have no power to grant relief in respect of related agreements, which are, for example, regulated mortgages. Easily done. But what else could Parliament have done, my lords? Let's look at 140A5. All this does, as I explained yesterday, is identify an exception to the introductory language in section 140A1. I asked the rhetorical question, why is it formulated in this way? Which then opens the door to TSB's argument. And I answered it because it's drafted by reference to the introductory language in 140A1 as to the type of agreements which engage the jurisdiction. So you need the carve-out. And if the intention, my lords, was to bar any relief in respect of exempt agreements, even qua related agreements, it would have said, it could have said, let me give you two options. First, it could have said an order under section 140B shall not be made in connection with a credit agreement or a related agreement, which is an exempt agreement. It doesn't say that. Or, even more simply, it could have said an order under section 140B shall not be made in connection with an exempt agreement. Full stop. There is no answer to that point. It is conspicuously not drafted in that way. It is drafted to limit the type of credit agreements which can engage the jurisdiction, or as, forgive my informal language, the gateway. Once you are through the gateway, related agreements can be taken into account for all purposes, including relief. And I come back to this absurdity, not dealt with by the bank, that you take into account the mortgage as per the judgment of the judge below for all purposes, the entire evaluative process, the entire trial takes into account the unfairness arising under the related mortgage. Uphill and down dale over the entire relationship. And you see in references in the explanatory note, the Treasury paper, the House of Commons paper, the purpose of this is to govern the entire relationship between debtor and creditor. But yet, having taken the mortgage into account at stages 1 and 2 of the judge's analysis as he broke the points down, including to work out what relief should I order. That was part 2 of his assessment. Nevertheless, having reached the court's view following trial, you have to stop short because there's this hamstringing provision. It makes no sense.
Could an order be made under section 140B in respect of a related agreement entered into under the bounce back loan scheme, or is that precluded by subsection 6?
Well, my learned friend raises the bounce back loan scheme. I'd rather agree with the view tentatively expressed by my Lord Justice Newey. It's not a great point. The bounce back scheme, I'm approaching the matter as a practical point, but no one has ever suggested, to my knowledge, that a COVID loan offered by the British Business Bank owned by the Secretary of State for Business could be made available in connection with an unsecured loan that would in and of itself, as a standalone agreement, qualify as a credit agreement. I'm not aware, and there's certainly no suggestion by TSB in this case, that has ever been the position. So I know I'm testing the point by reference to the prevailing position, but it's not, in my submission, a very good point, because the idea that people have unsecured loans, or businesses had unsecured loans which qualified, which then brought with them bounce back loans, is just baseless evidentially. So it's just a bad forensic counter-argument that's raised against me there. Now, one have to recognise, my lords, that the word related agreement, or words related agreement, are different. It's not in connection with a credit agreement, it's different. And you will have seen from the judgment below that my predecessor on this issue, Mr. Campbell, made the different words, different meaning principle. And I'll just give you the reference, if I may. You'll be familiar with it, but it's in Benyon, Authorities Volume 2, tab 34, page 654. There is no reason why a regulated mortgage contract cannot fall within that rubric of related agreement and be the subject of relief. As I say, it's consistent with the notion that the court takes into account the entire relationship in judging whether there's been unfairness, the nature and extent of it, and what relief should be ordered. And it's wholly anomalous, the outcome for which the bank contends, where the court can't then give expression to the views it's reached. And there are all sorts of potential difficulties here, with different defences, different forms of redress, additional resource for claimants. These are claims typically pursued by claimants in the county court. It's one thing to say, well, you've pleaded by way of alternative in this group action with a large team. But what about where you're an individual borrower and you get to trial and someone says, well, hang on, you haven't pleaded your Section 138D FISMA claim under MCOPS as a litigant in person? It's ludicrous, this suggestion that we should be pursuing alternative cases. And
sorry, can I understand what you're saying there? You seem to be making the submission, and if I've misunderstood, please tell me, that a claim under the CCA 1974 as amended, somehow less legally technical than a claim under MCOPS, and therefore more available to a litigant in person.
No, it's a different. Forgive me, my lord. I got carried away with the rhetoric. No, the point I'm making is that this, and I'm really engaging with a point that my Lord Justice Baker raised with me yesterday about alternative remedies. That the alternative remedy requires someone to be aware of all of these different rights under different regimes. And if they're not going to have to be pursued in parallel with additional resource and so on and so forth, that you're going to be aware of them and then plead them in the alternative.
I'm sorry, I'm still not following the argument. I'm sure it's my fault.
No, my lord, I'm sure it's fine.
Of course, we understand that in the real world, people have the problem that they have theoretically legal remedies, but to exercise those legal remedies, they face the problem that they're complex, and therefore, number one, they may not actually in the real world be aware of what their legal rights are. And number two, even if they have some awareness, they may find it difficult to enforce their legal rights because of the complexity of the law. So I understand that fact. But what I'm struggling to understand is why that applies more to MCOPS than it does to CCA 1974, because this looks pretty complicated too.
Well, we haven't got onto the total charge for credit regulations yet, my lord. It's a slightly different point. which is about the need to pursue multiple.
But why is it multiple? Because if you're a mortgagor, why not just go on doing comps?
Well, what relief are you going to get under your unsecured loan? I'm asking the question back to my lord as a, it's not meant to be impertinent. It's meant to be
If your claim is in respect of the loan, then you can go under CCO.
but then you can't get relief in respect of your related agreement on this basis, that you can invoke, you can take the related agreement into account for all purposes of adjudicating unfairness. But when it comes to relief, you have to pursue a completely
Okay, well,
different
I think
course of
now I've
action.
understood the
I'm
point you're
sorry.
making, which is that there should be a one-stop shop. Yes?
That is the intention.
Right. But how is a one-stop shop for the consumer consistent with the regulatory policy, which is we regulate mortgages separately from consumer credit?
And I will come to that because I addressed you on it briefly yesterday. It's not the case. There is significant overlap in the regime. I did mention it yesterday, I'll mention it again in a moment. The suggestion that the court should strive to achieve clear blue water between the two, and in so doing create this, in my respectful submission, absurd situation where the mortgage is taken into account throughout debate, but then taken out of account right at the very end, is not right.
A litigant person struggling with this area of the law might start with the explanatory notes to the statute. And we were shown the explanatory note to section 140A at page 611. And they might start with the second sentence of that, which says that section 16C exempts consumer credit agreements secured on land that are regulated by the FSA under.
And I'll show you again, I'll show you this in a moment, but the very next subsection of that clause, of that section, made it clear that that exemption did not apply to extortionate credit bargains. I may be referring to the wrong explanatory note. But when 16...
Page, sorry, I didn't tell.
The
They only showed us page 611.
yes, forgive me, my lord.
The explanatory notes to the
Yes, and if you...
CCA 2006, paragraph 48, that deals with section 140A. I'm only just taking this up because you're concerned about litigants in person. So people have had a struggle, like any non-expert in this area, with the provisions. And they might read that as being a clear indication that that section 148 doesn't apply to agreements secured on.
Well, and if it did, it would be misleading, because if you turn up the provision, the section of the statute to which it relates, which you'll find in the same bundle at page 381. Look at 7A. It disapplies all of these exemptions, which is why, when you go back into 140A, you need 140A5, and I appreciate, my lord, it was late in the afternoon, and I was doing it quite fast, and it's very dense material.
Are you saying that what we have at 48 on 611 is not an accurate reflection of the law as it currently is? Is it the wrong explanatory note?
No, sorry, with apologies, would you mind directing me to the paragraph you are looking at?
611, this is what Mr. Delaney showed us.
Yes, I'm on it.
Tab 32 in the authority.
Which
Paragraph 48 is where we were told by Mr. Delaney that this is the relevant explanatory note for section 140A.
I'm not sure it accurately reflects the position. The way I explained it yesterday and the approach I stand on is that this exemption at 6C is then disapplied by 7A so far as concerns 140A and 140C. It's labyrinthine.
Can you just help us what Is this the current version? Because the note on page 379 tells us that this version has been superseded.
Yes, because it was,
This is
when-
the version, as I understand it, as of the 6th of April 2007.
yes, there was a further version when section 16 was removed completely. If I recall correctly, I went through this briefly yesterday, but there was a further version when section 16 was removed completely and the entire exemption regime was moved into the RAO. So I'm seeking to address the position at the time when the RAO was first brought in, and that happened, and then the unfair relationship regime was brought in 3 or 4 years later. I went through the history step by step yesterday.
I'm
And
so
consist-
sorry, my
sorry,
lord,
yes.
I'm just not following at all. Is it being said that this is not the right version?
Well, can I just explore it for a moment? The explanatory notes we've got at tab 32 are for the Consumer Credit Act 2006. If you go to the version of section 16 that we're looking at, the subsection that you're pointing to is subsection 7A.
Yes.
As the note to subsection 7A explains at page 383, note 21, that was inserted by the Consumer Credit Act, unless the reference to the statutory instrument makes any difference. On the face of it, it was inserted by
It's
the
the right
Consumer
one.
Credit Act.
That's the basis upon which I'm addressing it.
Yeah. So your point is, well, perhaps the explanatory note is wrong because there's an explicit exclusion of section 16 exemption in relation to sections 140A to C pursuant to the 2006 Act.
And that is why, and forgive me, my lords, if I'm going back over ground I went over yesterday, but hopefully it's helpful. That is why, when you go into 140A, if mortgages are not going to be qualifying agreements or gateway agreements, the credit agreements you can rely on, you've got to have 140A5. So otherwise they're all, and you'll remember I showed you 140C1 as well, which defined credit agreement broadly. That's where 140A5 fits into the analysis. And I'm reminded that the explanatory note you were looking at, which my Lord Justice Baker just referred me to, has the usual wording at paragraphs 1 and 2 that it doesn't replace the Act, etc. The usual caveats. So one does have to retrace the history here quite carefully. And I stand by the analysis I set out yesterday, appreciate at pace, but 6C provides that regulated mortgages are outside of scope. 7A makes it clear that doesn't bear at all on 140A to 140C, which is a regime of its own. And 140A to 140C identifies what you need to qualify, which is a credit agreement that is not an exempt agreement.
I mean, you say, well, if Parliament had meant what Mr. Lady says, it could have said it differently. It might be said that if it meant what you say it meant, it could have said it differently.
Well, I would respectfully submit that those two examples I've given you about how 140A5 could have been drafted are a complete answer here, because it would have been so easy to draft the provision in that way if it was intended to have the A far-reaching but B anomalous outcome that you have stages 1 and 2 of the analysis as set out by the judge include the mortgage, but stage 3 doesn't.
What about if Parliament had simply said in 140A1, you can make an order in connection with a credit agreement other than an exempt agreement?
I think we all await the cheers for when we reach it.
I mean, we could always say that Parliament could in one way or another made things clearer.
Of course, and it's the poor parliamentary counsel who suffers the submissions of counsel in court. But nevertheless, it's a very odd way of drafting it, all this. if the intention was for no, for mortgages effectively to be out of bounds when it comes to relief. It's just a very strange way of doing it. It's not what you would do as your first port of call or second or third in my submission. And you have to ask yourself, what are the words make an order under section 140B in connection with a credit agreement doing? Identifying, it's right there in the very first clause, identifying when this jurisdiction is engaged. Now, can I just deal at this point perhaps with the legislative history? Now, it was said the court had this power that I've referred to make orders or grant relief in respect to the regulated mortgage for a short period. It wasn't a short period under the extortionate credit bargain regime. It was a long period. You'll see that set out in the addendum. And it was also remained the position after the regulated activities order was introduced. This is my credit bargain point. And it's right, this point. Notwithstanding what was said in the other explanatory note that you were shown, or the Treasury paper, or indeed the parts of the House of Commons research paper that my learned friend referred to, I gave you references yesterday to the parts I drew your attention to in particular. The definition of the word or expression credit bargain was not changed. And so the radical regime change that you are asked to believe took place when the regulated activities order and FSMA came in is not as radical as was being suggested at all.
But in terms of your long period, I mean, the period before that change doesn't really matter, does it?
Well, it remains the position that the court had that power under the regime, and nowhere in any of the documents that the banks seek to admit in aid of their construction do you see any suggestion at all that the powers of the court were to be narrowed in any way, whether relating to mortgages or otherwise, where they form part of the bargain or relationship. And we may have dealt with this already, but my learned friend showed you the exemption. She showed you the footnote in the House of Commons research paper at page 562. It was the same point that I just traversed with my Lord Lord Justice Baker. Those exemptions, and in the previous version of section 16, in the previous version of section 16, there was a footnote that you would own that says mortgages, in summary, are being taken out of account. It's volume 2 of the authorities, tab 26, page 365. I showed you this yesterday. If you turn the pages, it's exactly as it read for the unfair relationship provisions. 368. This act is not regulated a consumer credit agreement if, this is when the RAO first comes in, but look at 7. So again, I'm afraid that footnote on which the bank relied, not right. Now, it has to be assumed that Parliament has chosen consciously not to do what my learned friend suggested it must have wanted to do. It would have been easy to change, and I'm now addressing you, if I may, on that period when the RAO and FSMA are coming in, but you've still got the extortionate credit bargain regime. It would have been easy to change. Again. But what was done very carefully. First of all, sub 7 here. Second of all, the amendments are in the next tab to the extortionate credit bargain regime, Parliament is surgical here. It amends the definition of credit agreement precisely in the way that I say 140A5 operates, so that you can't have a qualifying agreement which is a regulated mortgage or gateway agreement or the one that invokes the jurisdiction, but it doesn't change credit bargain. It does not exclude regulated mortgage contracts from this, and when you look at the relief that is available under 139, page 375, you will see that sub one, it talks of reopening a credit agreement. But when you read down sub two, and by way of example, the end of little b and the end of little c, you can make orders in relation to the entire credit bargain, which includes the regulated mortgage. And that was not changed. This was done with care. Regulated mortgages were not simply extracted wholesale from the regime. This is not a lacuna, as has been suggested. So where does the bank go to next to try to deal with this point? It takes you to the total charge for credit regulations. They say, oh, you wouldn't take a mortgage into account. With respect, why not? If you look up, the court is looking at which agreements make up the total charge for credit. We really are in deep archaeology here, but we're hopefully suitably equipped. And what do you take into account under, it's tab 19, page 346, subject to certain exceptions. It's what's provided for in Regulation 4. The total of the interest on the credit under the agreement, under the credit agreement, but also other charges at any time payable under the transaction. No reason there why you wouldn't include a related mortgage. And you look at then the definition of transaction, which you'll find in the previous tab, tab 18, page 344. It's the final definition in subsection, or in Regulation 1, brackets 2. And there are, again, exceptions in Regulation 5, but an agreement, any transaction which is a linked transaction by virtue of section 19(1)(a). I can clarify that definition has not been changed, so the version you have in the bundle is correct at all times. It's never been amended. So any transaction which is a linked transaction, which takes us back into the type of connections that are available under a related agreement now under the unfair relationship regime. You'll remember I showed you that in the definition of related agreement in section 140C4. Now just a couple of points here. First of all,
Can I be clear? Is it your submission that the qualifying words, as we discussed earlier, which the creditor requires to be maintained, may not maintain as a condition of the making agreement, don't apply to the transaction by virtue of section 19(1)(a)?
that's correct, my lord. I say it doesn't matter for my analysis because I'm right either way. That's really important. This debate that's taking place before you does not turn. But for what it's worth,
But if,
it can't
as
be
was
right.
pointed out earlier, if you say that those words merely qualify any other contract to which the debtor or a relative of his is a party, then they wouldn't apply an agreement. So if you had any agreement, then that would suffice.
Oh, I see what you mean by the first reference to an agreement. Well, it doesn't sit well in my submission. As I say, nothing really turns on this point. But in my submission, it doesn't sit well with the linked transaction definition, which in and of itself has as one of the menus, as one of the options on the menu, effectively the same provision. So if you turn up the definition of linked transaction at tab 15, page 332,
Well, before we go to that, can we just try and bottom out the question on the qualifying words? Because I'm not sure I've got your answer yet to the question about an agreement.
Well, it doesn't appear to be particularly
Any other contract with
yes, it doesn't appear to be particularly heavily drafted, but the provision that I'm referring to at present, any transaction which is a linked transaction, appears to be, in my submission, is not confined or tethered.
I think it's got to be, because otherwise an agreement just isn't.
Well, it may be, my lords. Let me, perhaps those bigger and brighter brains around.
But since an agreement
No, I see the point.
precedes the linked transaction, if you say linked transaction isn't governed by the words at the end, then neither is an agreement,
I
which makes no
understand
sense.
the point that my lord's making. But it is odd, because when you then look at the definition of linked transaction, and I know my lord Augustine wanted to bottom out this point in isolation, but you would have to read these provisions together. And linked transaction has this as one of the options under the menu.
I see that, and so on the face of it, transaction is narrowing which sorts of linked transaction can
It would
count.
have to, if the interpretation of adding of those words at the end applying to all the previous options in that regulation, if that's right, then each of B and C within 19.1 would also have to be entered into. Now, why do I say nothing turns on this? Because we really are here at the outer
I mean, we
reaches
talked
of
about litigants in person earlier. The more we look at this,
Yeah.
the more sorry one feels for any
Well,
litigant in person.
It was ever thus, I suspect.
Especially if they can't rely on the explanatory notes.
The civil procedural
Can I
rules and
just,
Miss Lady.
just because this is coming for a new point, that it's only linked transactions under 19.1a. I think my learned friend misspoke when he suggested B and C were.
Oh, that's true.
Sorry, in this case,
If you
no,
look
there's
at
a pleading that extends that. The pleading is not limited to 19.1a.
but if you look at the definition of transaction, that's tied to 19.1a.
That I see, my lord.
Exactly.
Now,
Yeah.
it is pleaded as such in this case. I mean, we're not actually under this legislation. We're looking at this legislation for the purposes of working out what we can take from it for now. But for what it's worth, it's pleaded in that way. It is also pleaded under different options under the linked transaction regime, where we're not subject to the total charge.
Sorry, what's the relevance of the pleading? We're trying to understand legislative history here.
I totally agree. My learned friend interrupted. I thought, and forgive me if I've got this wrong, to clarify the nature of the case that's being
No,
filed.
I think she was pointing out that there isn't an oddity in saying that the linked transaction B and C don't apply, because actually the definition of transaction excludes B and C.
Exactly.
Don't take those into
Yes,
account.
well,
Which one do you
or it would have to be B and C, but with the additional aspect. In which case, you would be
No, well, it
within
isn't,
a
because if you look at the definition of transaction at page 344, it says
Oh,
an
yes,
agreement.
19.1a, I'm sorry.
Yes.
I'm sorry. Quite so. In which case, the words at the end, effectively, so far as at least the reference to the transaction under 19.1a, add nothing, I think, because that requirement is found in 19.1a already. So I think that, with apologies for having taken that long to answer that question, I think that is the answer to that question. Now, nothing turns on this, because that remains an option for the related agreement under the current legislation. And for what it's worth in this case, we do pursue it on that basis, amongst others. But as my lord says, the way it's pleaded in this case doesn't bear on the legislative analysis or indeed history. Now, so that doesn't really take us anywhere. The reference to a linked transaction is closely analogous to the current one. In fact, if anything, it goes in my favour. Because as a point I made yesterday, as a broader policy point, is the court need not be concerned about floodgates or slippery slopes or undue overlap, because of the need under the current regime for the related transaction to be just that, as defined, which includes a linked transaction, and that it was indeed very similar under the prior regime. If anything, the requirement for the connection was closer. And the court isn't in a position now to reach a view on whether mortgages would or would not have been falling into that category. We say in this case, for example, as an example, if they do, it's denied and it's a matter for trial. So this definition here and this excavation of the total charge for credit regulations in my submission doesn't add anything. And references, for example, to concepts such as APR don't assist either, because the question is simply, you take into account other charges payable under the transaction. You shouldn't gloss that. So you would, if the mortgage is a linked transaction in 1918 under the old regime, you take into account the charges payable on that mortgage, and you can grant relief by reference to that mortgage. So
Just on this question of the definition of transaction, I don't know if it's a point for you or against you, but we're puzzling over this reference to an agreement, and I noticed that agreement is itself a defined term. This means a consumer credit agreement. So we understand the definition to say means a consumer credit agreement, comma, any transaction which is a linked transaction, etc., comma, any contract for the provision of security relating to the agreement. Now, does that assist us to then understand what is qualified by the qualifying words?
I think it would rather, thank you, my lord, first of all. Secondly, I think it does suggest in my submission that those words at the end are qualifying only the last part, because we don't end up with the possible anomaly or possible absurdity of any agreement at all without the tether at the end. Could be taken into account. What you take into account is a consumer credit agreement as defined there, any transaction under 19(1)(a), which is linked, a contract for the provision of security relating to the consumer credit agreement, that makes sense, and any other contract where you do have the tether. So, with thanks to my Lord Justice Arnold, I think we've got to the bottom of that particular right.
Well, yes and no. I mean, on the basis that you just outlined, it helps us understand the definition. Where does that leave us with regard to the legislative history? Because you're still then asking, well, is the transaction in question one of the specified categories? And even on that basis, you've still got to find either a consumer credit agreement or a linked transaction or a security contract or a contract which has the qualifications.
I think the consumer credit agreement will be the gateway type agreement here. And then the others will be the equivalent of what is now permitted by related agreements and are to be taken into account as part of the extortionate credit bargain analysis. My lords, and so it does closely mirror in my submission in terms of its architecture, fundamental architecture, the approach that we say is the architecture of the unfair relationship regime. Now, so I'm just going to try and wrap up on issue 3 quickly, subject to any further questions from my lords. We stand by our analysis of the history here. It is highly relevant because the case law repeatedly emphasises the importance of the context. There was this power under the previous regime. Absolutely was. The documents we've seen and the Supreme Court decision in Smith confirm that the intent was to make the provisions more consumer friendly and less technical, and to confer upon the court the broadest possible powers. And my learned friend added the word to refer to the extortionate credit bargain regime as discredited. Well, what we say is that it was considered inadequate, and crucially, in what respect This is in the skeleton. Too narrow, too tough on consumers. That was the point of 40th paragraph 43 of our skeleton. And closing on the policy point, my learned friend briefly suggested, but then I think qualified the suggestion that mortgages could never be related agreements. It was initially floated as a point of principle, but then suggested as a point of practice. I don't follow with respect how it can be a policy point if it's a matter of practice. So it's not in the pleading. It's not before the court. But it's completely inconsistent with the broader policy point I made yesterday, which is relevant to the issue before you, and which is that credit agreements themselves have become subject to FSMA and FCA regulation later on. There is, for example, a consumer credit source book in the FCA handbook now, just as there is in relation to MCOBs. But credit agreements remain gateway qualifying agreements under the unfair relationship regime in the Act. And the same is true, I mentioned this exception for consumer credit-backed mortgage contracts. These are generally older mortgages, second charge mortgages, but they're still treated under the various legislation that bites as credit agreements, which open the gateway, because for historical purposes, that was considered fair. So they are both regulated by FSMA and the FCA and subject to the unfair relationship regime. And you'll see them referred to, for example, at 30A of the amended particulars of claim. So where consistency, continuity, coherence, or indeed fairness requires, there is no difficulty with a degree of overlap. So there is no force in my submission in the suggestion that the court should somehow be allergic to any overlap between the two regimes. And it really would be bizarre if, as trial judge, one found that the mortgage was highly material to the unfairness, and that there should in principle be a remedy to rectify all of the unfairness, that the court could not follow through with that and make appropriate orders. Whereas it makes perfect sense that if all you have is a regulated mortgage, you cannot enter the unfair relationship provisions. And that is the effect of 140A5. My lords, unless I can assist you further on that issue, I propose to issue on issue 1.
Could I just briefly go back to the point which was troubling us a few minutes ago about exempt agreements? Where do you say we find, and this may be a very simple question for so late in the day, what is the meaning of exempt agreement under 140A5?
It is a cross-reference to certain agreements which are referred to in the regulated activities order, if I'm not misspeaking.
Okay. So that's covered. That is covered in your skeleton, isn't it?
It's an exempt agreement for the purposes of Chapter 14A of Part 2 of the RAO by virtue of Article 60C2, and it refers to their, effectively, categories of agreement, including broadly, crudely regulated mortgage contract. And I think home purchase plans are referred to also. So it's a sui generis.
Thank you.
My lords, I'm conscious of the time, always reminding myself that that clock is 5 minutes fast. It's the lifeline, the gift that keeps on giving. Issue 1.
So we don't need bundle to the authorities anymore, we need the supplemental bundle.
Please, thank you. My lords, I'll try and deal with this crisply if that's possible. The key issue is whether, and it's important to frame this issue correctly, is TSB permitted, was it permitted to do what it has done under the express terms? TSB say they have not transferred to their own rate or one of their own rates. That is their case. There has been no transfer to their or even one of their SVRs. They accept, and it's page 32, lines 4 and 5 of today's transcript, that if they are to transfer, it has to be to a pre-existing rate. They accept that the Whistletree rate is not a pre-existing rate. What they say they've done is vary the Northern Rock SVR, or in the words of the offer letters, Northern Rocks SVR, apostrophe S. And they focus on attacking our approach but present no coherent explanation of how this contract actually really works, whether now or in ordinary market conditions. I understand that. They just need to knock us out. But when you're considering rival contractual constructions, one does have to consider what you're actually presented with by way of alternative. The law, I maintain my points, no response on Lord Newberger or Mr. Justice Newberger. And what he says does
I
complement.
think the response was, we're bound by the Supreme Court. It was as short and as simple as that.
Maybe, and I say that case to which you have would in capita is not dealing with the consumer context. You lean in favour of the consumer here. Offer letters and the language they contain. We do rely on them for condition 22, but it's also interpreting the contracts generally. You have to look at these documents as a whole. It's not just about conflict. They are part of the contract, and you can't just distance them away by saying, oh, we're not interested in particular facts. I don't rely on someone's name or address or the amount they pay. These offer letters have been included because they are typical exemplars. They are part of the standard form. So to the extent the cases that TSB rely on, which are not consumer cases, have any relevance here, these letters are part of the standard form. And indeed, they have primacy. And that's why they've been included in the bundles and agreed to be typical exemplars. And my learned friend sought to analyse away the word prevailing, what I rely on. It connotes a rate that exists at the relevant time. In my submission, it isn't consistent with the creation of a fresh rate. And that takes all the more force when you read it with the other words, which TSB skips over because they cannot deal with them. Existing customers. No answer to that, nor any real explanation for how a reference to Northern Rock's standard variable rate can then be a rate that TSB, a completely different entity, can vary. I'll come back to clause 7.2 in the point.
I'm just getting a bit confused.
I'm sorry, my lord.
No, it's my fault. If you go to, it's page 170 of the bundle, isn't it?
Yes, my lord.
So that's where we find the guarantee. Now, you're not actually relying on the guarantee as such.
It's not pleaded as a breach of guarantee, it's
No.
pleaded as a breach of contract.
So
all the language in the pleading is set out there.
but you're not complaining of the fact that the rate is set no lower than a particular figure. You're relying on these words as colouring what we find elsewhere.
Yes.
Now, prevailing, Mr. Laney says, well, that means at the relevant time, effectively. What do you say it means?
I say it does mean at the time, but it's very difficult to reconcile in my submission with the creation of a fresh rate. Now, I'll come back to that because TSB say they haven't done that.
Yes.
But effectively, what I'm arguing against now is the suggestion that they've taken the Northern Rock rate and varied that.
So that's what I'm just trying to understand. In terms of that way that the case is put by TSB, how does this advance us? Because they start with what was a pre-existing rate, a prevailing rate. And indeed it applied for existing Northern Rock borrowers. So what's wrong with the starting point?
Because the reference in the prior sections of this letter are to the Northern Rock SVR, standard variable rate, or Northern Rock's standard variable rate. And if you're looking at asking yourself what can be done on transfer, what you can't do as a transferee is vary someone else's rate. The Northern Rock SVR is the rate set by Northern Rock from time to time.
You accept one of the things they could do was to apply the inherited rate.
Well, I'll come back to that because that is a limited circumstance which is intended to address the facts as they have in fact transpired. And I'm going to engage in a moment with my Lord Justice Newey's possibility or hypothesis. But what happens if Northern Rock is still trading? Everyone agrees.
And parking that for one moment longer, since I probably set a red herring going there. If we come back to the definition of standard variable rate, where you get the two possibilities.
We're now in the conditions, my Lord.
Yes. I'm just trying to relate it one thing to another. So on TSB's case, they're not relying on the second possibility. They're relying on the first possibility. And they say, well, once we've taken over, we effectively means TSB, and therefore we can vary what's been set using condition 7, and indeed in circumstances where we have taken over the offers, nobody else can have the right to change the interest rate because that's passed to us.
Well,
So what's wrong with that?
what's wrong with that is that it relies on a number of matters which are not tenable in my submission. First of all, heavy reliance, notwithstanding what was said, in fact, heavy reliance on the capital I in interest. And there was heavy reliance below, and it formed a significant part of the judge's reasoning. And that simply doesn't work in the post-transfer world. It's a classic Chartbrook situation, where if you follow it to the letter, it does not work. Secondly, it divorces the first half of this clause from the second half. And as I say, it makes the second half surplusage. Now, what we're faced with, again, standing back, is we end up with a rate that is not Northern Rock's SVR. This is really important, nor TSB's SVR, nor even one of them. That is where we are now. That is what TSB has done. It's important to engage with the granular, and I do and I will. But the position we are now in is a situation where we're not being charged Northern Rock's SVR. That doesn't exist. And we're not being charged TSB's SVR. That is not permissible. Now, I've offered you, my lords, two ways of dealing with clause 1.2, which make this definition make sense. First of all, as a step into either option, you have to recognise that the word interest with a capital I makes no sense if you treat TSB as the lender in that sentence with a capital and keep the capital I. It's Chartbrook. And I did explain in detail yesterday why that doesn't work. It has all sorts of unintended consequences, including that for every time you republish the conditions on this analysis, you could have another SVR, which makes no sense. It also makes perfect sense, as letter I, when you're looking at the position when Northern Rock is the lender, because it makes its loans, offers its loans under its general conditions. So it's coherent. They're all under condition 6. It's a standard rate. My learned friend attacks the claimants for their reliance on words like standard. And yes, of course, we have defined expressions. But we can't descend into a Narnia where we lose sight completely of what's logical or sensible. And so I developed that yesterday at some length. And you have to then recognise. And so your option one is to be pragmatic about the capital letter I in the first sentence. And as the court was in Chartbrook, post-transfer recognise it can't be referring back to condition 6 with all the problems that brings. The fact that a clause that is, I'm afraid, devoted primarily to mechanics drives the entire analysis of pricing under the contract. This capital letter, which because it cross-refers to condition 6, therefore it means only the loans under the norm. But when TSB inherits it, it just means that little subgroup that it's bought because of the one reference to condition 6 determines a crucial term as to pricing. That just cannot be right. Now the alternative, I dare say they could all actually be read together, or taken together, is that you recognise that the first half of this clause is looking at the position pre-transfer, and the second post-transfer.
Sorry.
I'm sorry.
Which clause?
sorry, 1 point, the definition of standard variable rate. I'm sorry.
Where precisely you say the second part begins, if we transfer. So the first part is pre-transfer first.
That is a logical and seamless way of understanding that clause.
I mean, one difficulty is the may in the second half.
It's
I'll
a
come to
major
that.
difficulty, isn't it?
I'll come to that.
Because just before we get into the may, can you help me on this? I mean, one of the things that puzzles me about this is you refer to this as a clause.
It's a definition.
It's a definition.
Well,
The operative clauses are elsewhere. So, for example, the second half, yes, it's present in the definition, but it's reflecting the operative clause which we find in condition 19.1, is it not?
That second half coheres with the second sentence of 19.1. And my lord, this is actually a point in my favour. The standard variable rate is a concept. It is there. It is those words. My learned friend says it's a number. Yes, of course. At any particular point, it should find expression somewhere. But it is a concept. It is the concept set out there. Now, the first half, second half analysis, again, I developed yesterday, and it makes this language work well. There is no problem with it. Now, I appreciate there's a may.
Just before you do, I'm probably misremembering. My recollection was that with the first half yesterday, you thought that we could be TSB.
Yeah, so there are two ways of doing this. I'd like to provide the court with options from which it can select. Option one, you treat it as effectively, you recognise that that reference to capital I interest has to reflect the pre-transfer position, because otherwise it doesn't make sense. That's a starting point. And then you can say, well, either it's what's intended here is the first section until if we transfer is intended to refer to the pre-transfer position. And the second, the post-transfer. And remember, we, us and are means Northern Rock or TSB as the context may require. It's very important that. It's not what it said in the definition, but everyone agrees that's how that must be interpreted. Or you can take the more direct or alternative Chartbrook approach and say capital R, capital I here doesn't really work. If I want to read we in the first sentence as the transfer then the capital I doesn't work. But if you don't like that, if you feel that's doing too much violence, notwithstanding what we said in Chartbrook, you can take the other approach, which is you marry the two parts of the clause up and you read them in a logical way.
I'm sorry, I think I'm misremembering your case, but
I'm sorry.
No, I think so. Yesterday you did accept that we might refer to TSB.
As the context may require.
Yes, and that would be post-transfer, obviously. So supposing that it does indeed post-transfer refer to TSB or is capable of referring to TSB, why can't TSB use that right?
Which right, my lord?
The right in the first half of the definition.
It can use that right in respect of the rate it applies to its variable rate mortgage loans, or our variable rate mortgage loans. It is not limited, as my learned friend suggests, to this sub-portfolio of borrowers who have been taken on from Northern Rock.
I follow it. So just to be clear, condition 7 will apply in relation to the first half. TSB could use condition 7. Is that right?
So we are assuming TSB has acquired the loans.
Yes.
And how would the first sentence operate?
Yes, so just supposing that it were able to arrive at a starting point in relation to the first half, it could then use condition 7 to change it.
Yes, but the language of its variable rate loans indicates that this is not a right that can be exercised by reference purely to this particular subset of borrowers.
So how does it work? At the moment when there's a transfer, but you're going to come on to the may, but on the face of it, the transferee gets a choice because it says may in the second half. It can go to its own regime if it wants to. But it's got a choice. So the choice has to be to take as its starting point what it's already got, presumably. I mean, what else is it going to do?
My lord, this is where I think I want to engage a little with my lord's hypothesis yesterday. Let's, and I just want to explore it. Let's assume we are in ordinary market conditions. There hasn't been the collapse and division of Northern Rock, which no longer exists as a commercial business in the same way. My lord floated the possibility that under these conditions, the two options might be the Northern Rock SVR, which you follow, and I think I'm understanding the possibility correctly, you follow passively.
That was what I was floating, but I don't think it's anybody's case.
Northern Rock, well, I'm using it to test what then happens when that Northern Rock SVR is no longer available. Because when you posit those two options, and we can see why my lord has floated that possibility. I don't put it any higher than that. Rights reserved, etc. But your two choices there are to passively follow the Northern Rock SVR, which that entity is continuing to set, or
continuing to change.
or
So how then does TSB's power to vary under condition 7 come in?
I'll come to that. It comes in if they decide to move to their own rate. But
How
that
does
is the
that
point.
work on the language of the definition? Because we may change this rate from time to time under condition 7, comes before the reference to transferring.
And that's why, my lord, I invite you to consider reading that definition as contemplating a pre-transfer and a post-transfer world. And that second sentence of current is entirely consistent with that. Now, what are your options in the world that my Lord Justice Newey has floated? You follow passively the Northern Rock SVR, Northern Rock's SVR, Northern Rock Standard Variable Rate, or you move to your rate and you vary that rate, those are the words of the contract, under condition 7. Now, what we have tried to do, now first of all, important point, there is no room in that analysis at all for what TSB has done. None.
What precisely do you say they did that they cannot do?
They purported to take the Northern Rock SVR and vary it. And what you end up with, in my respectful submission, is a no man's land rate. It is not Northern Rock's SVR, and it is not TSB's SVR, or one of them. Those are the options in this hypothesis that we're exploring now.
I think you've got to come to May. May say
Well,
4 o'clock.
yeah, with the May, but the May is the May is squarely engaged here. I don't retreat from the May.
Can I just put a question about the May?
If you don't transfer in this world that we're exploring now, if you do not transfer, you do not engage condition 7. It is not available to you as transferee, and your alternative option there is to follow the Northern Rock SVR passively. And my learned friend's answer to that, recognizing the danger of this example, is we can't do that because under clause 7.2, we can only vary the standard variable rate or increase it or in accordance with the subconditions provided. But when you are reading the position in this way, though we there in 7.2, where the Northern Rock SVR is being followed passively, can only be a reference to Northern Rock, as the context may require.
I'd like to ask you 2 points about May, if I may.
I'm sorry, please do. I'm sorry if I haven't answered.
So May, if I may, May is looking at the definition of standard variable rate. So we're in what you've called the second half.
Yeah.
Well, it says, what the transferee may do, they may change the rate. Do you accept that that gives them the option of not changing the rate?
Yes, I do.
Right. And what is meant by the rate? Can I suggest to you, it must be the current standard variable rate then applicable.
I think it would be the standard variable rate.
The current standard variable rate.
I think you change the standard variable rate to your rate, which you apply to your variable rate mortgage loans.
Yes. I'm postulating what happens if you don't do that.
And if you don't do that,
Yes. What are the options? If you've accepted that it may entitles you to decline to do that, if you do decline to do that, what are your options?
So,
I think the respondent's case is you have to stick to, my phrase not theirs, the current standard variable rate, which you can only vary under condition 7.
yes, they say they can take the predecessor rate and vary it. We say two things. One, we contemplate and engage with my Lord Justice Newey's possibility that your option, if the Northern Rock SVR is still there, is to just track that. And can I just, I'm just exploring it, but the answer that was given that is not a possibility is not right. It was said we can't because we can't move it up and down unless under condition 7.2. But that's the point of 7.2 is that it will apply to Northern Rock where it's the Northern Rock SVR. If you move to your own rate, then we means TSB.
Yeah.
And so,
And
that's
I don't, with respect, think you've answered my question. What happens if you decide not to do that?
Well,
Which I think you've accepted. Forgive me.
on the
I think you've
present
accepted that is an option.
on the
What
yes.
can you do then in those?
On the
What
present-
must you or can you do in those settings?
Sorry, I keep cutting across you, my lord, I'm sorry. On the present facts, because we're not in the world that my Lord Justice Newey is contemplating, what I explained yesterday is that we seek to give expression, nevertheless, to that word may, even in a world where the Northern Rock SVR no longer exists. Because one option could have been to say, well, you must, in that case, where the Northern Rock SVR no longer exists, move to your own rate. We've tried to adopt a less extreme course, which is to recognise that the word may is there and to give it some expression in the unforeseen circumstances that have in fact eventuated, because no one would have anticipated what in fact has happened. And so the way we put it, and it's in the skeleton, it was in the preliminary issues trial skeleton at paragraph 60, if I recall correctly, and I sought to address you on it yesterday, but I appreciate we were unpacking things together at the time, is they can take the prior rate as a limited qualification. The prior rate would endure. But
Just so I'm clear, because I think we should, as far as possible, try to use, thinking of the poor litigated person here. The rate, the words in the order.
let me put it
in the
differently.
conditions.
Let me try and
Is it that you buy prior rate? Do you mean the current rate?
I mean the inherited percentage,
Okay. Current rate.
the actual figure.
What could you then do with it?
You cannot vary that, because to vary, if you are to get the benefit of condition 7, you must move to your own standard variable rate.
Okay.
And stepping back, that makes perfect sense, because TSB cannot vary Northern Rock standard variable rate, can't vary HSBC standard.
Is that in the interest of the consumer? Because you just told us that on this basis, TSB, if they didn't adopt its own rate, was stuck with the inherited rate of 4.79%, and therefore could not lower the interest rate.
Whatever happened to the market, which I think dropped, didn't it, after this?
Well, overall, it went the other way.
But let's assume there'd been a market crash.
I follow that. Now, this is what we are positing a means of making this clause work in unforeseen circumstances, and this is where you would not expect that position to endure, or an abuse of the kind contemplated to take place. And this is where the implied terms, which have now been conceded,
But isn't my lord
Okay,
right?
okay.
Doesn't the TSB interpretation, which is that if they decide not to change their rate, they're stuck with the rate, doesn't that protect the borrower, the vulnerable borrower, because they're not going to be any worse off than they would be if the loan book hadn't been transferred.
well, they don't accept that they could have, well, they, as I understand it, I mean, I don't know what their case is on what the position would have been if Northern Rock carried on trading. They've not engaged with that possibility. But
I think they have. I assume their case would be the same, that they,
but
as transferee, would have inherited the right to set the interest rate and so on.
what we contemplate is a very limited carve-out to address the unusual combination of economic conditions that prevail that result in the current factual scenario before you, and accommodate the word may, and make all of these clauses work in ordinary market conditions in a way that is consistent with the language. And the Northern Rock SVR can only be a rate set by Northern Rock from time to time. It was a very, it's a, with respect to bizarre interpretation. You're the consumer reading your offer letter, and it's now a rate that is set by TSB. And I would add, without any reference to its own commercial considerations, because as I explained yesterday, it's simply adopting a rate fixed by reference to the commercial considerations of a predecessor, which faced completely different economic conditions, indeed a liquidity crisis, and then it just moves it up and down with base. It doesn't reflect market conditions or its own economic position. It's not what you'd expect in a pricing clause. It's not how you would expect profit, for example, or benefit to be allocated under a contract. Sometimes we talk about allocation of risk. This is about allocation of benefit. My lord,
So I've understood your case on this. If they elect not to change their own rate under the second part of the definition, they have to adhere to the existing rate indefinitely.
and
right?
well, no one would be expecting that, and it's explained in the skeleton, but it would not be anyone's expectation that that rate would endure for any significant period of time. Because if nothing else, the market factors that you would expect to operate, which very unusually don't operate here, because you have the point about the closed book, and you have the point about it being my case that my clients are effectively locked in for affordability reasons. So in
What's the
order,
power to change the rate then? If they're not- so they're
you
not
move
stuck.
to your own rate. So if you're concerned about market constraints, competition, reputational factors, all of the things that motivate pricing, you move to your own standard variable rate or one of their own, and you vary it from there. There's no difficulty for them.
So just pursuing it a moment longer, but picking up the points made by my lords. So suppose TSB had acquired the loans when the prevailing rate was 9%, which is not impossible. It went up to nearly that. TSB would have the option of going to its own rates in circumstances where interest rates were much lower, but it couldn't be under an obligation to do that, could it?
Well, the commercial constraints of the market would mean that it would end up doing so if market rates are falling, and
But-
assuming that you are in a competitive market, which would normally be the case.
But on this closed book, with borrowers who can't otherwise refinance, there wouldn't be much of a market force requiring them to move from 9% to their own rates, and they would have no power to vary the rate except by doing that.
Well, first of all, we're assuming here, the assumption is that TSB do not wish to reduce, because if they wish to reduce, it's easy. They move to their own standard variable rate and reduce from there. There is no problem from the lender's perspective here. That's
It
important.
prevents them adopting the halfway house. I mean, take my lord's example. Suppose the inherited rate is 9%, but TSB at that point in time are charging 5%. Then on your construction, what TSB can't do is to reduce the Northern Rock Whistletree people to 7%.
No, they could move to their own rate, and then increase that if the conditions in 7.2 were satisfied.
But a borrower could have no cause of action at all if they stuck at 9%.
No, if we are layering extreme scenario upon extreme scenario, which I appreciate why we're doing that to test, that's when you get your implied term.
But what implied term could require TSB to exercise their right to go to a rate of theirs rather than to stick with what
It's
currently
acting other than as a reasonable mortgagee ought to, bearing in mind the obligations they're under to treat customers fairly and et cetera, as now pleaded and just to a large extent conceded.
So it's
My
not.
lord, that's not the implied term that's pleaded, nor
No.
has it been, quotes, conceded. If my learned friend wants to advance a case in the implied term, he should show you what it is.
I mean, for any implied term to operate, it's got not merely to be something that could prevent TSB from doing something. It's got to be something that could compel them to do something.
It would be something that could provide the consumer with relief in the event of it not being complied with. And the implied term, and I'm not trying to redraft it, it's set out in the judgment, would operate in those circumstances.
You've accepted that we includes after transfer TSB.
It can do as the context may require.
So why shouldn't we in the third line of the definition of best benefit fair rate, including TSB after transfer? So after TSB has taken on, has acquired entitled annuity offers to the loan book, why can't they, as the we, change the rate from time to time under condition 7?
If we put to ones, if we recognise that the capital letter in those circumstances at the start of interest makes the definition unworkable for the reasons I gave yesterday, then the standard variable rate means such rate as we, TSB, applying TSB through in that position, decide to set on our variable rate mortgage loans, which would mean the TSB SVR, not the Northern Rock SVR. And yes, under the third sentence, TSB can then vary its SVR. What it can't do is vary the Northern Rock SVR. And I make the point that on TSB's interpretation, even if Northern Rock had continued to trade in its original form, what it could have done would have been transferred different parts of the loan book to different subsidiaries, none of which had pre-existing SVRs, and on TSB's case, each of them could have then applied different SVRs to each of the different loan books, each of the different subsections, which can't be what the parties intended and would fundamentally undermine the bargain. And I made that point yesterday and there's no answer to it. And so I say, contemplating my Lord or Justice Newey's world and the world I've just, and the point I've just made, why does this change? Why does this change when the Northern Rock rate no longer exists? Why suddenly can TSB, when previously it would have had to either track passively the Northern Rock rate on this analysis or move to its own, why, when the Northern Rock SVR no longer applies, suddenly can it purport to vary the Northern Rock rate? Nowhere does the contract allow for that. Now, and what they seek to do instead is to lean into this exception that we've identified, which tries to give expression to the word may in unforeseen circumstances. And they then try and use that to reverse engineer the analysis. But we say that doesn't, you cannot upend the entire analysis by reference to the exception. You cannot draw out the rule from the exception. The Northern Rock SVR was and is a rate set by Northern Rock from time to time, and it does not become a rate set by TSB. So if you want to vary as transferee, you have to move to your own base rate first. And that's the effect of the language that one sees at 1.2, the definition of standard variable rate 7.2, and all the more clear when read with the offer letters. And I repeat that 7.2 subsections point specifically to factors affecting TSB's own position. And it does not read at all well, it does not cohere well with the notion that you take someone else's rate and then apply your own commercial factors. And the difficulty was recognised by my learned friend when she said today at page 41, line 17, that the variation under clause 7 would have to be applied to one of the lender's own SVRs. But nowhere is there any language in this contract that permits the Northern Rock SVR to be mutated into a TSB SVR. And again, consumer contract, important, crucial pricing clause. If there was going to be such a provision, you would have expected to see it, and it is adverse to the consumer, and this is not a hindsight point, because where you give someone options of that kind, they are likely to exercise them in their own financial interest. It will invariably be to the detriment of the consumer if they have the power to vary another rate. And there's no difficulty with 7.2 in the analysis, the options I've countenanced. My lords, I'm almost finished.
Well, we've delayed you rather.
Not at all, my lord. And my lords, one only runs into difficulties with my analysis, or indeed any analysis, if the Northern Rock SVR is not there anymore. And we've catered for that. Now, securitization, briefly, I do maintain that these retail borrowers would not have been contemplating a transfer to a securitization vehicle. I know what the first sentence of 19.1 says, that these are retail borrowers. And I do respectfully maintain that the second half of the definition of SVR and the second sentence of clause 19.1 are contemplating or envisaging a transfer to an active lender with its own SVR. They're not contemplating a transfer to a securitization vehicle with no pre-existing SVR. And that's also consistent with the language of the offer letters.
What about a new entrant into the lending business?
Which would typically...
So they could be an active lender, but they wouldn't have a pre-existing SVR.
They will. It may become a matter of a scintilla of time, but if you're going to be an active lender, you will have an SVR of your own that you're going to be applying.
Why so? So I want to enter the mortgage business, and my business plan has two steps. Step one, I acquire this existing portfolio, and then once I've got that up and running, in 6 months' time, I'm going to start new lending.
My lord, if I may, as I understand it, it's actually not disputed that if you're going to vary under this contract, it's contemplating varying to an existing SVR. So that was my understanding of the submissions being made by my learned friend. So, but I take the point. One can, of course, conceive of factual possibilities that don't cohere perfectly with what's contemplated. But the question is, what is being contemplated? And what is being contemplated here is a transfer to a lender with an SVR, or more than one. And I maintain, my lords, that when the judge said as a transfer of a mortgage was more likely to be to a securitization vehicle, that he did so with a respect without evidence. It's paragraph 90 of the judgment. What you were shown in response to that submission was evidence as to what has happened after, following the collapse, and how the book has been parcelled out. That is after the event material. And so you're being invited there to fall into the same analytical error as the first instance judge respectfully fell into on several occasions, which is to construe the contracts by reference to events which long post-date them. The relevant question is what would have been considered or contemplated by the parties to have been more likely at the time of contracting, so far as a future transfer was concerned, and there was no evidence before the court on that point. My lord, can I conclude? My lords, can I conclude now with this point? Standing back again, you know I have referred to the profits that are being made and which are referred to in the amended reply. That's not an ex post point. The point about these very significant profits, which are out of line, far out of line with the profits that Northern Rock that TSB is making on its other mortgage books, it's precisely what you would expect to happen if you allow the bargain to be undermined in the way that it has been. This is about allocation of benefit under the contract. And the borrower is entitled to the protection that comes with having the benefit of a standard variable rate that will typically be constrained by market conditions. You will not set it too high because you would drive borrowers away. That is the protection. That is why you sign these contracts. Despite not knowing what the number's going to be, you know it's going to be one that is going to be regulated by the market in ordinary market conditions. And what happens when you allow that bargain to be undermined and for the transferee lender to adopt a rate set by reference to completely different economic circumstances, indeed a complete collapse, and just run with it and move it up and down with base rate? You get exactly the outcome of these extraordinary profits being made at the expense of the claimants and others. And doing that is simply not permitted under the bargain. You have choices. One of them is not taking the pre-existing rate and then simply varying it up and down as they have purported to do.
My lord, I'm sorry to rise, my lord, it's obviously been going for a while. That is completely unsupported by evidence, and we object to that being said in open court on the basis of absolutely no evidence at all.
Yeah.
There are points I could make in opposition. I'm happy to do so if the court wishes. Anticipate you won't, but just to note that that's not an appropriate submission.
My lord, I'm not trying to tread into inappropriate territory. I'm trying to simply advance my client's case. The references to the profits are to the TSB's own annual reports. I don't take it any further than that.
Only, even for the purposes of your case, the figures are immaterial. The concept you've explained.
It proves the point effectively in practice. But to take the point, I'm not trying to step outside of the realms of the appropriate submission.
Yeah.
My lords, unless I can assist you further.
Thank you very much. Thank you very much, both of those of you with speaking roles, for very clear and helpful submissions. Thank you too for those who haven't had speaking roles for their assistance. You won't be surprised to know that we're not going to give judgment here and now. You will receive the draft the normal way for you to correct our English and typing, but that won't of course be an opportunity to re-argue the case. We'd be grateful if at the same time you would seek to agree an order dealing with consequential matters. If there are any points on which you can't agree, can we please have brief written submissions, and we would expect to deal with the points in the order that we make. Finally, though I'm sure you're all very familiar with this, I ought to remind you of the importance attached to the embargo. There are still regularly cases where the draft goes to somebody who shouldn't receive it. That obviously shouldn't happen. If you think of anybody we don't already know about who should see the draft, you obviously need to come back to us. But thank you very much for your help.
Sorry, so I'm not trying to wind anyone up too.
Yeah, I mean, I think we just don't accept that you can show those that we're making profit.
Sure.